So the Supreme Court denied emergency relief in two cases which are trying to stop the state of Illinois and their rifle and magazine ban. This, of course, is not great for the gun owners in the state with this upcoming looming registration deadline, but there is still a little bit of hope that we need to talk about, and there's a lot of context about what happens with these cases in this issue going from here. So let's talk about what is happening. But real quick before we jump into the video, if you think a rifle and magazine ban is obviously unconstitutional, go ahead and hit that like button and subscribe. Also, I want to thank one of the main supporters of this channel, which is Kershaw Knives. Kershaw makes some of the best knives available on the market if you're looking for a quality EDC knife. I carry a Kershaw Iridium knife every single day for my EDC, and right now if you go to Kershaw using the code YT20Scholar, you can get 20% off of your order and free shipping on orders of $50 or more. So check out Kershaw Knives, use that code, it'll be linked down below. And again, thank you to Kershaw Knives for supporting this 2A content. Also want to mention briefly that today is the last day to vote for the Gundies. You can vote for myself and other channels using the links down below. I am nominated for the top 2A voices and then also Influencer of the Year. So if you'd like to vote for me and then be entered also to win a bunch of prizes, including a trip out to the Gundies to hang out with me and a bunch of other people, you can do that. Again, links are down below if you would like to vote. So like I mentioned in the intro, in this video, we're going to be breaking down two recent orders by the US Supreme Court which denied emergency injunctions and emergency relief against the state of Illinois and their rifle and magazine ban. Yesterday, while I was out training out at the range, doing the Achilles heel tactical training, the baseline carbine, I saw some news hit, and there was a bunch of news surrounding the fact that the Supreme Court recently denied two emergency injunction relief, two emergency requests, essentially asking for the Supreme Court to put a temporary halt on the statewide rifle magazine ban in the state of Illinois. Now, the two cases we're going to be breaking down and talking about in this video and discussing what happens now are the Colkins v. Pritzker case and then also the NAGR v. Naperville case. These cases involve a challenge to the Protect Illinois Communities Act, or PICA, which placed an unconstitutional restriction on rifles and magazines. PICA also requires a registration requirement for certain firearms to be grandfathered in for these individuals in Illinois to be able to continue to possess them. And there is a registration deadline in a registration period that is set to end at the beginning of next year. Now, these two cases have two different procedural backgrounds and histories, which are also very important, especially in light of what recently happened with the Supreme Court denials. In Colkins, the case was originally brought in an Illinois state lower court who, on review, entered summary judgment against the state of Illinois, declaring that this ban on rifles and magazines was unconstitutional for denying equal protection under the law. That state lower court ruled and found that the rights to bear arms under the state and federal constitutions are fundamental rights. Therefore, the challenged legislation was subject to strict scrutiny, which the legislation did not satisfy. So that was the ruling of that lower court. Therefore, the state lower court ruled that PICA was void and unconstitutional. Now, of course, in response, the state of Illinois then appealed the decision up to the Illinois State Supreme Court. And on review, the Illinois State Supreme Court reversed the lower court's decision. And in that case, there were also a bunch of concerns about some contributions that went to two of those Illinois State Supreme Court judges. We talked about this before in this case and other videos. There is some information that two of those judges potentially received millions of dollars from the defendants involved in the case, and maybe that led to some bias, and maybe they should have either been disqualified or recused themselves. So that's also part of this Colkins case. Now, after that Illinois State Supreme Court decision, the plaintiffs in this case then filed a writ of cert to the U.S. Supreme Court. Now, what is critical for what is now happening in this case is the fact that the state of Illinois also filed a notice of waiver to the U.S. Supreme Court. In the waiver, the state of Illinois identified that they will not file the required response brief, which was actually required to be filed by December 14th, which they did not meet. Now, in response, the Supreme Court accepted that waiver from the state of Illinois and then actually set this case, Colkins, to be reviewed, considered at conference on January 5th. So that's also important to keep in mind that even despite the recent emergency injunction denials by the U.S. Supreme Court in this Colkins case, there's still a conference set for review in this case for potential consideration by the full court, and that is on January 5th. Now, in the meantime, while that traditional writ cert was filed, Colkins and the plaintiffs here also filed for an additional emergency stay request pending Supreme Court review by Justice Barrett. What this means is that on top of the traditional writ filed by Colkins, there was also an additional filing of an emergency stay request that went to Justice Barrett for her or the full court to issue a stay on Pika, at least until the court decided what they wanted to do after January 5th. Well, again, yesterday we received an order by Justice Barrett that simply states, Culkin's application denied by Justice Barrett. So this emergency stay request was denied by Justice Barrett and did not go to a full court consideration in a full court denial. So one important thing that I want to point out with this and this denial by Justice Barrett specifically is the fact that since she denied it on her own and didn't go to a full court consideration and full court denial, that means that there is a potential still that emergency request could be refiled to a new justice. Under the Supreme Court's rules, whenever an emergency application like this is filed, it goes first to the justice responsible for that area. Here, Justice Barrett is responsible for the 7th Circuit. She essentially gets first crack at either reviewing or denying or granting or accepting that review. She can also refer to the full court, which they often do. Here in this case, she reviewed it on her own and denied the application. So that means that there is the option for the plaintiffs here to refile the emergency stay request to a new justice like Justice Thomas. So again, they could file to Justice Thomas if they wanted. However, I think the likelihood is that Justice Thomas, even if a emergency application was refiled to him, he might still then refer to the full court, and then you would still see a full court denial like we saw in the NAGR case. So a refiled emergency request is an option. There's also the fact that the full writ petition is still up for conference on January 5th. That means this case is still very much alive despite some of the commentary you hear going around, and this Culkin's case is still moving forward. There are some options, but again, just not super great news. I would have preferred, of course, a stay be granted against this Illinois ban, at least until the Supreme Court decides what they want to do on January 5th. Now, the second case that was denied an emergency request was the NAGR v. Naperville case. The NAGR lawsuit is a little different in its posture because NAGR did not file the traditional Supreme Court writ first, and then also request an emergency injunction like in the Culkin's case. That is primarily because the NAGR lawsuit was still pending and seeking 7th Circuit en banc review. However, as we've discussed in some recent videos, the 7th Circuit recently denied en banc review in multiple Illinois rifle and magazine ban cases, and that included a denial of en banc review in the NAGR case. Again, yesterday we received an order from the court denying this emergency injunction request. The order of the Supreme Court simply reads that the NAGR application, and then they state the application number, for a writ of injunction pending certiorari presented to Justice Barrett and by her referred to the court is denied. So that's simply all the order states. Now, unlike the Culkin's case, since this went to the full court and was denied, that means that the emergency injunction request at this time is done. NAGR, however, still has plenty of options. The main one being that they can and will likely actually file for Supreme Court review. They will file that traditional writ of cert and ask for the Supreme Court to actually review the full case and not simply just ask for an emergency injunction. But again, will that actually give the gun owners in Illinois immediate relief? No, it won't, but at least it proceeds this case forward. No dissents were also issued in this case or any of these cases, which is interesting because you would think that if there was any speculation by either Justice Thomas or Alito, or there was any understanding by any of those super pro-2A conservative justices that the Supreme Court was not going to review this issue at all, that they were going to let these complete bans on rifles and magazines stand and then potentially open the floodgates for other states, you would think that they would at least issue some sort of language or dissent in these denials. But we didn't see any of that, especially we didn't see any of that in the NAGR case, which went to a full court consideration. Remember, Justice Thomas is the one who not only authored Bruin, but before Bruin was authored, the prior Supreme Court had considered multiple cases, multiple 2A cases, and multiple times in dissents, like the California waiting period case Sylvester. Justice Thomas stated that his colleagues were treating the Second Amendment like a second-class right. And if you want to get this shirt, which states that the Second Amendment is not a second-class right, you can find it using the links below. This is an Armed Scholar shirt, so if you guys want to support the channel and then also get something that clearly states that the Second Amendment is not a second-class right, you can find this shirt using the links below. So again, I think something is potentially brewing, because if there wasn't, I would have no doubt at least Justice Thomas would have made a statement in these denials. So definitely not the perfect situation. We would have wanted the Supreme Court to issue some sort of injunction and some sort of temporary relief for these cases to move forward, for gun owners to be protected because of this looming registration deadline. But of course, like I mentioned, the Supreme Court has denied emergency relief in 2 of these cases. I suspected that they would. I said that in multiple videos, but there are still some options where these cases can move forward. There are some options for some potential relief. Like I said, the Culkins case could refile for some sort of emergency relief to another justice like Justice Thomas, but it's definitely becoming more of a dire situation for those gun owners in Illinois. I understand your frustration and your concern because of these Supreme Court denials, and we will have to watch these closely moving forward, see what develops, and if anything else changes, I will let you guys know. So if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But regardless, thank you guys so much for all of your support, and never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.